And again, against the High Court's order, the department filed an appeal to Supreme Court, and a judgment was sought from this particular apex court. And what the Supreme Court said is that, one, it sided by the High Court's judgment, which said that the activity should be exempted or considered and not the person. It is irrelevant as to which person had used the accommodation for residential purposes. The ultimate purpose or the activity or the use was residential dwelling or residential purpose, and therefore GST will be exempted. Look at the activity and not the person. Number one. Number two, don't make a narrow interpretation or a literal interpretation of the word must use for residential purpose. Only the use matters and not the ultimate user. So don't do a lateral or a literal or a narrow interpretation. Number two. Number three, if you do such kind of an interpretation, then it will ultimately defeat the legislative intent brought out by the government of providing GST exemption. Because if you charge GST on detailed spaces, they'll ultimately charge it to the final students or the working professionals, for which the fee of staying would be quite high. So if you interpret it very narrowly, then in a narrow manner, then definitely it will defeat the legislative intent of this particular GST exemption clause.